All right, thanks very much for coming out to hear about what I think is an extremely important topic. So let me dive right in. So 2015 was not a good year for free speech, in my view. It began with the attacks. Let me see if I can make this work. So it began with the attacks in Paris on Charlie Hebdo, and if I can fudge the calendar a little bit, it ended with the shameful conduct of the Italian government in covering up classical statues so as not to offend Iranian diplomats who were visiting. So you might think of it as terrorism on one end and craven appeasement of those who support terrorism on the other. Or another way to think about it might be it began with tragedy and ended with a different kind of tragedy, but in the middle there was a lot of farce. And by that I'm referring to what's going on America's campuses today. If you've paid any attention to this, I'll summarize it now and talk a little bit more about it as I go on. But you might summarize it as college students cowering in fear, demanding trigger warnings and safe spaces to protect themselves from controversial and scary ideas. So to sum up the point, I think that free speech is really under attack in the world today. One way we might think about what we stand to lose if we lose free speech is to consider, again, what the Italians did when these Iranian diplomats came to visit in covering up statues that represent the very soul of Western civilization. And that's kind of how I think about the right to free speech, that if we lose the right to free speech, we have lost the essence of Western civilization. If we think about Western civilization as springing forth from reason and independent thought and creation, losing the right to free speech prevents us really from taking advantage of everything that our minds and our ability to create gets us. To put it in terms or to borrow a way of thinking about this from Ayn Rand, she once described organized society, the benefits of organized and civilized society as twofold. First, the division of labor, and second, the accumulation and dissemination of knowledge. If we don't have free speech, neither of those things is possible. We can't really cooperate effectively, and we can't certainly accumulate knowledge. Really, progress dies. Now, what I often run up against when I give talks like this across the country is the question, well, wait a minute, America's different, right? America is different. We have a First Amendment. Won't the First Amendment protect the right to free speech? And there's a lot to be said for that idea. I mean, certainly the First Amendment has protected free speech throughout the 20th century. While there are many problems with what the courts have done in this area, the outcome, ultimately, the conclusions that the Supreme Court has reached in the last 50 years or so are quite good. We do certainly enjoy protections for free speech in this country. With limited exceptions. So one might say, well, the First Amendment is enough to protect us. Now, I don't think that's true, and I certainly wouldn't be here giving a talk with the title, Is the First Amendment Enough? If my answer was just going to be, yep, it is, thanks, I'm out. Right, there's much more to it. So to kind of get into the point, let me quote an authority on freedom of speech and the Constitution. Let me set this up a little bit. This is James Madison, obviously, and I'll read the quote in a moment for those who can't see it, but let me just set up the context. As most of you know, or many of you know, James Madison initially opposed the Bill of Rights, adding a Bill of Rights to the Constitution. And it took a while before the Bill of Rights was added to the Constitution. And his argument, he had a couple arguments. The primary one was, look, the Constitution is a document that establishes a government of limited and enumerated powers. If we add a list of rights that are supposed to be protected, two possible things can happen. One is the implication might be that the government has the power to violate these rights, and we've just gone and set up a government that doesn't have the power. right? So we don't want to create this implication that, that the government has extra powers that aren't in here. And secondly, if we list out the ones that we can come up with, that always inevitably is going to leave out a whole list of rights that aren't in there, and by implication, aren't we saying that, that those other rights are not protected anymore? The second part of this, they took care of with the Ninth Amendment. The first part, ultimately, Madison just conceded that it was important. But now, one of the other arguments he made, and it's captured in this quote, this is a letter he wrote to Thomas Jefferson. Jefferson and Madison had a lot of interchange on this issue. Jefferson was a big proponent of adding a Bill of Rights, and he ultimately obviously won the battle. But this point I think that Madison makes is a good point. So here's what he says, as you probably already read it. Experience proves the inefficacy of a Bill of Rights on those occasions when its control is most needed. Repeated violations of these parchment barriers have been committed by overbearing majorities in every state. Parchment barriers was a term that the founders often used to refer to law and constitutions, as you might think of it as, yeah, they're important, but ultimately they're just parchment barriers. We need something more to protect our liberties and our rights than just what we list in this document. Now he goes on, I didn't include the entire quote, but he goes on to say, in fact, most of the violations that we've seen of rights come not from government acting on its own against the will of the people, but really the reverse of that. It's majorities of the people acting through government and essentially using government to achieve the ends that they want to achieve. So here's how I would put the point, and I think Madison would agree with this point. Ideas are more fundamental than laws. Okay, laws are based on more fundamental ideas. And if those ideas are not consistent with the laws over time, the laws will become consistent with the ideas. In other words, if you want to preserve the constitutional system that we have, if you want to preserve your rights, you've got to preserve the underlying foundations of those rights. We've got to understand what they are, and we've got to support and argue that those rights and liberties, and indeed our entire constitutional system, is worth protecting. If that goes away, if people tend to, or ultimately come to view our rights as not worth protecting, it doesn't matter what the Constitution says. The laws and all of the protections for our rights will fall to more fundamental ideas. So that's kind of, I would call this the theme of my talk. That's what I want to illustrate tonight. And I think I can kind of, I don't know if I would say I can prove it, but I can make a really good case showing the connections among ideas and the kind of incidents that we've seen in the last year, and then court decisions and laws. You can see a common strain among them, and in my view, the news is not good. So here's essentially what I'm going to do. I'm going to cover 4 basic areas. First, I'm going to talk a bit about culture, and by that I mean public views and attitudes about freedom of speech. So what I'm talking about here are how have people reacted to the many controversies that we've seen over the last year? And the last year is really just a microcosm of a broader trend that I think has been going on for a couple decades now at least, which is a turning against freedom of speech. And so the types of incidents I'm talking about, of course, Charlie Hebdo, the Garland, Texas attack, and a number of other things. So I want to look at the public views and attitudes about that. Next, I want to look at ideas. And what I'm talking about here is, simply put, what do the intellectuals think? Now, this is really the most important part of the argument, because the ideas, in my view, are ultimately what control or lead to public attitudes. And then the final point being, what is happening in the courts? How do they interpret the First Amendment? But what I'm starting with illustrations of what's actually happening, kind of the retail version of ideas, to illustrate that there's something going on here. And then I'm going to talk about those ideas themselves. We're going to illustrate how you can see a connection between the ideas and the culture, and then also the ideas and the courts. But the fundamental point is this: it's ideas that matter. It's ideas that control people's views, or ultimately lead to and motivate people's views of things like freedom of speech, and ultimately will determine, in my view, the direction not only of the culture but of our laws as well. So let's jump right into it then. Oh, sorry, my last point is, I forgot about the most important point, which is that in order to change things, we need better ideas. So what we need to argue to win the battle for not just freedom of speech, but as I see it, the Enlightenment tradition and really Western civilization is what ultimately is at stake. Okay, so starting with culture. Now, what I want to talk about then are a handful of the incidents that took place this year, but more than just the incidents like Charlie Hebdo and the Garland attacks. It's what did people say? What characterized the public reaction to these things? So let me start with the Charlie Hebdo attacks. And I'm going to use Gary Trudeau. Gary Trudeau, as most of you know, is the author, the cartoonist of the Doonesbury comic strip. And he was given an award not long after the Charlie Hebdo attacks. And he took the opportunity to really criticize Charlie Hebdo. And this characterizes his view. He was essentially saying they're not acting as proper satirists. You know, you've heard the phrase that satire should afflict the comfortable and comfort the afflicted, and instead, as Gary Trudeau said it, Gary Trudeau put it, Charlie Hebdo was, quote, punching downward at a disenfranchised minority, right? Now think about that for a minute, disenfranchised minority. My reaction every time I hear that is, well, they weren't so disenfranchised that they couldn't get their hands on a bunch of AK-47s and go murder a bunch of people in an office. So I'm not really sure what the point is. But, and I'll get to summarizing this a little later, but I want to go through some of the other incidents and some of the other reactions. But Trudeau, I think, really captured a view that after the initial kind of support for Charlie Hebdo died off, this view really settled in quickly. And we saw it not only with the Charlie Hebdo attacks, but, well, actually, sorry, I'll get to the Garland attacks. This is another example of the same kind of thing. PEN, P-E-N, is like an authors guild. It's an organization that supports authors around the world, and they've long been really stalwart supporters of freedom of speech. They gave an award for courage to Charlie Hebdo, and PEN, I think, remained quite heroic in this respect. But the quotes that I have up here are from a dissenting group of authors who wrote a letter to this organization protesting the award for courage going to Charlie Hebdo. And the way they put it was Charlie Hebdo expressed a kind of cultural arrogance against those it was criticizing. And one of them said that accused the magazine of pushing a kind of forced secular viewpoint. Forced secular viewpoint. This kind of gives a new meaning to the idea that the pen is mightier than the sword, or maybe I should put it as somebody's taking that expression a little too literally, right? The sword actually wins in a fight with the pen, hands down, every time. And yet we have people, in the face of the murders of practically the entire editorial staff of Charlie Hebdo, criticizing them for cultural arrogance and trying to force other people to accept a secular view, which is really crazy. Now, the Garland attacks. Garland, Texas, this was Pamela Geller, whom many of you know of, put on a contest, Draw Muhammad contest, and as I'm sure you're aware, they were attacked. Thankfully, nobody was killed other than the terrorists themselves. But here's what we saw after that. The New York Times wrote an op-ed. A lot of other people really criticized Pamela Geller and others, calling them, trotting out the epithet Islamophobic, or calling them Islamophobes, and claiming that they were spewing hate speech, and in effect blaming the victims. And the idea was, it's not really their fault for attacking you, it's your fault for being attacked. You stirred all of this up. And then finally, let me take an example from college campuses. You no doubt remember the protests at the University of Missouri, which was over allegations of racism on campus, which in itself wasn't really, I think, or is at least not particularly pertinent to my point. It was the reaction of a lot of the students, in particular, blocking reporters from trying to film and photograph this protest. Now, keep in mind, they're on a public space, right, university space. Presumably the idea is these kids want to get their ideas and their views out there. And yet they're preventing photographers from taking their pictures. Why? You probably don't remember this, but their basic argument was, we want a safe space so we can, quote, control our own narrative, right? Which is absurd when you think about it. I mean, it's an actual public event. And so they're protesting, and yet they want to control what anybody has to say about this incident. But there were many others on college campuses as well, many other examples of this. And I can, if people are interested in more, I can talk about more of all of these types of examples. But this is really just to give you a kind of flavor of what the year held in terms of people's views, or a lot of the views that we are seeing more and more on not only on college campuses, but in the opinion, among opinion leaders as well. All right, so let's sum up the points. The first point is that is contained in these attitudes, and others like them. Speech equals oppression, threats, and force. So punching downward, forcing your views on other people, safe spaces, right? So I'm protected from your speech. And there's many more examples of kids, and in college campuses, this is widespread, where students will claim that they feel threatened, actually threatened by the views of other people. Not just I don't like what you have to say, but I feel unsafe. Another thing that we can see, another idea we can see emerging in this is emotionalism trumps reason. So Islamophobia, what does Islamophobia even mean? Did anybody ever stop to say, hey, maybe there's a reason to criticize Islamists, you know? Maybe there's something going on here, and we shouldn't just brand it as a sort of psychological condition, but actually analyze what's happening. Same thing with hate speech. It's a meaningless term that people can throw or brand any form of speech that they disagree with as just embodying hate, right? So it's just you're throwing your emotions at me, I don't care what you have to say, and everybody is against hate, therefore we should be against anything branded hate speech. And then of course students feeling threatened by speech. Again, it's I feel threatened. Are you actually threatened? No, I just feel threatened. I feel bombarded by what you're saying. And then the final point is altruism, which is captured in the Penn reaction, the reaction of those dissenting authors in calling what Charlie Hebdo did cultural arrogance. The idea being, who are we to look down on any other culture? And then the call by Gary Trudeau, you can see this altruism is infused in practically this entire issue. It's constantly, we ought to sacrifice our views and our ideals to anybody who objects. And typically it's, the supposedly oppressed and downtrodden. Now, before I move on to the issue of ideas, I said the next thing I'm going to talk about is where does all of this come from? Where do these sort of retail views of free speech come from? And of course, it's philosophers and opinion leaders. And I'll get to that in a minute. But what I want to do now is give us a kind of quick dose of reason. One way to think about what is going on throughout this entire issue is a point that Ayn Rand captures in an essay called Faith and Force, The Destroyers of the Modern World. And her point is, and as she says it, there are only two means by which men can deal with one another, guns or logic, force or persuasion. Those who know that they cannot win by means of logic have always resorted to guns. And that's a really key insight. Irrational ideas lead to force is another way to put it. Now we can see this, I think, in, I'll give you two concrete examples of this idea at work. One is a little more obvious than the other, but let me start with the more obvious one. So this is Bosch Faustin's drawing that won the cartoon contest that Pam Geller put on in Texas. And the point is well made here, right? This is Muhammad saying, basically, if you draw me, I'm going to murder you, right? So I don't like what you have to say, or you disagree with me, you have a difference of opinion, and my response to that is murder, right? That's a real nice crystallization to the idea that if your ideas are irrational, you're ultimately going to use force. And of course, we saw that with the Charlie Hebdo attacks and many other attacks going all the way back to Salman Rushdie in 1989 at least. The next one is a kind of secular version of the same thing that's not quite as obvious, but how many people remember this quote? I need some muscle over here. This is Professor Melissa Click from the University of Missouri protests. And this was part of, there's videos online that you can watch. And a young guy at the University of Missouri tried to videotape the protests. And there was a lot of outrage by that. They were blocked. And then a person comes up to the camera and tells them to stop filming. And when he refuses, she turns around and says, I need some muscle over here. Basically, I need thugs to remove this kid from, from this public space in which everybody has a right to speak. So I think that's a nice example of, and I'll illustrate this more in terms of the ideas when we get to them, but it's a nice example of Ayn Rand's point. If you can't use persuasion, you're going to use force. And if your ideas are irrational, force is exactly where you're going to go. So let's turn then to the next point, which is the idea. So where are all these attitudes coming from? So I want to start with a couple philosophers, and then I'm going to show you the same parallel ideas that we just saw among legal philosophers, and then ultimately I'll show you the same ideas seeping into the courts. So the first one's a bit long, but I'll explain who this guy is. This is a guy named Stanley Fish, a fairly famous postmodernist, so kind of a new leftist philosopher from the 1990s was when he was very popular. He taught at Duke, and he was a very influential thinker in the PC movement, if anybody remembers the PC movement of the 1990s. So I'll just sort of summarize or give you snippets of this, but you can get the basic idea from the first sentence. Abstract concepts like free speech do not have any natural content, but are filled with whatever content and direction one can manage to put in them. So ideas are meaningless. They're just hollow, right? They're just, you could think of it as they're just words, and we fill them with whatever abstract or whatever content we feel like it. Free speech, in scare quotes, is just the name we give to verbal behavior. So there's the idea that I talked about before, the idea of equating speech with force that serves the substantive agendas of, and I just bracketed it here, but the bottom line is those in power, right? Free speech, in short, is not an independent value, but a political prize, okay? We fight over who gets to define what free speech is in the arena of politics, right? And if that prize has been captured by a politics opposed to yours, you could just finish it as your SOL, right? It is now an obstacle to your purposes. Now, a number of things are captured that I just talked about. Concepts and ideas are hollow. But one of the ideas that's embedded in this is we are naturally clashing and opposed to one another. So to think back to Ayn Rand's quote, right? If you can't explain your ideas, if your ideas are not rational, you are necessarily going to have to use force. This is Stanley Fish saying, essentially, I agree wholeheartedly with that, and our ideas have no rational content, and so really what we have to do is do battle in the political arena. Okay, remember what the political arena means. What is it that government has? What is it that government does? It's force, right? So what Fish is saying here is we have to use government, essentially, to some groups and individuals will ultimately dominate others, and the proper responses for those who have been dominated or oppressed to dominate back, to grab the reins of political power and use it against their oppressors. And this is really de rigueur in the new, in postmodern thinking these days, and the new left certainly since the 1960s. All right, the next one is from a philosopher by the name of Thomas Nagel. And this captures another idea that I alluded to before and is very much in the culture these days, which is egalitarianism. But you really have to read this one and think about it to absorb the full implications. A person does not deserve his intelligence, nor the rewards that superior intelligence can provide when racial and sexual injustices have been reduced, i.e. when the old forms of injustice have been reduced. We'll still be left with the great injustice of the smart and the dumb who are differently rewarded for comparable effort, right? So it's unjust to be smart, right? And to use your intelligence. I mean, this is where this leads, and I'll show you in a minute where it logically leads. But that's ultimately what he's saying. You're not, it's pure luck that some people are intelligent and other people are not intelligent. And it's a great injustice. So what happens if you think that this is an injustice? My point earlier that ideas matter much more than law. So my first example of this, of legal scholars, is a guy by the name of Owen Fist. And I say, his ironic First Amendment because he wrote a book called The Irony of Free Speech. I think the irony to him is that it leads to things that he doesn't like. But in any event, this is a quote right from the beginning of it. Because of what, his egalitarian views, to put it that way, and because he believes that there are sort of, as he calls it, differential power relationships in society, and that's unjust, sometimes government, quote, may have to silence the views of some in order to hear the voices of others, right? So this is, we need censorship in order to tamp down on, if you put it in the terms that Nagel said, to tamp down on the smart and the articulate so that the unarticulate and dumb can be heard. It's not freedom. Whatever that may be, it's definitely not freedom. Second one, Cass Sunstein, many of you have heard of him. He was the regulatory czar under Obama for a while, taught at the University of Chicago Law School. He's now at NYU. I say his New Deal for free speech because he wrote a book called Democracy and the Problem of Free Speech. These things are opposed to one another. I mean, democracy is a vague term, but what he calls for is a New Deal for free speech, very much like the New Deal that occurred in the 1930s, which, if you'll recall, was massive growth of government and what set in motion really the regulation of every single thing we do. And this is what he's saying we need for free speech. And in a minute, I'll explain why he's entirely right if you accept his premises. But just two quick points. So what he wants is the FCC ensuring quality program and a diversity of views. Now, he wrote the book in the 1990s. Maybe program, well, I think programming was probably a lot worse back then, but imagine what it would look like today in what many people call the golden age of television if the FCC started deciding what's quality and what's not quality, or in any event, deciding on what a diversity of views looks like. You've probably heard of the fairness doctrine. This was an idea that was in force in, God, I can't remember exactly when, the 1960s, I think, in which the government enforced a kind of fairness of news broadcast, and it decided on what was diverse and what was not diverse. The same idea they tried to apply to newspapers in, I think, the 1970s. And of course, Sunstein's a fan of stricter campaign finance laws to fight inequality. The next one is Justice Stephen Breyer. This is a book, this comes out of his book called Active Liberty. And of course, he believes that, as many people do these days, and as I'll show you where this idea comes from, that the purpose of the First Amendment is purely to serve democracy. But what he says here really dovetails with what Cass Sunstein's point of view is. And this, again, is a very prevalent view among intellectuals. If we apply strong free speech guarantees to everything government wants to do, that would unreasonably limit the public's substantive economic or social regulatory choices. Now, again, I would say he's absolutely right about that. So Ayn Rand once put the point this way. She said, a free mind and a free market are corollaries. Okay? You cannot have a free mind, meaning free speech and free thought, if you also have economic controls or controls on your behavior. Because the whole reason to think is to act, right? We're not just disembodied minds floating around. We want to do things in the real world. The same thing is true in reverse, right? If you regulate our activities, our business activities, you will necessarily ultimately end up having to regulate free speech. And this is Stephen Breyer saying, I agree with that wholeheartedly. Think about it as, what are economic regulations if they aren't regulations that tell us that we have to make different choices, right? It's a form of paternalism. It's, you're not smart enough, you don't have the right amount of information, you're making bad choices. You are exercising your rational faculty the wrong way, and we want to control your choices, right? That is what restrictions on free speech are all about, controlling your thought and your choices. So all these guys are saying things that are entirely consistent either with prior government controls and laws or the ideas that we saw from the more philosophically minded earlier. So again, if we sum up, we come up with pretty close to what we had earlier. So abstract ideas have no content. They're just verbal acts that some use to oppress others. And the way I think about that is reason is impotent, and if reason is impotent, might makes right. And that's, I mean, there are philosophers many philosophers throughout history who have made exactly that point. It's unjust for some to be smarter or more articulate than others, and government should equalize voices, so equality of speech over freedom of speech. The purpose of the First Amendment is to serve democracy and the public good. This is a point that I'll return to in a minute, which is basically collectivism. If you take it seriously, if our right to free speech is really just the handmaiden of whatever somebody deems the public good, we're essentially forced to act for the good of society. That's what collectivism is. And collectivism and statism, or really variations on the same theme, are entirely inconsistent with freedom of thought and freedom of speech. All right, now let's take a look at what the courts have said. And I want to, so again, you might still say, but we still have a First Amendment, right? And it's still, even, I mean, these ideas have been circulating in the culture now for decades, and yet the Roberts Court, the Supreme Court under John Roberts is still really good on free speech. So you might still say, okay, interesting, it was great how you connected the ideas to the culture, but I still don't see why it is that any of this would affect what the courts do. So let me offer this thought. Okay, so it's happened before. My two arguments really are this: history and logic, right? This is the history part. During the Progressive Era, late 19th century through the New Deal, 1930s, the Supreme Court essentially rewrote the Constitution. That's a bit of an oversimplification, but they interpreted the Constitution in a way that authorizes government to do practically anything. Okay, the progressives were primarily a philosophical movement. They had a whole different moral view, and they were explicit about it. They challenged the founders' views. They said those views are wrong and we need to replace them with other views, right? So they were big fans of Hegel and other German philosophers who were all collectivists, and they understood that their goal, right, as intellectuals was to undermine the founders' ideas, was to replace the founders' ideas of freedom and the pursuit of happiness with a kind of collectivism and a government or a society run by experts. And they largely succeeded. Why can't they do the same thing with the First Amendment? That's the First Amendment. Now, I want to ask you to read at least the red part of it. That's the really money part, right? So that's the part that applies to free speech and the press. Congress shall make no law abridging freedom of speech over the press. It's pretty clear, actually. But here's a question. And you don't need to be a legal, thinker or lawyer or philosopher to know the answer to this question, or to come up with a kind of answer to it. Is it the case, notwithstanding this language, or does this language, or just does the right to free speech as people commonly understand it, does it allow you to say anything you want in any context whatsoever?
No.
Okay. So let's take some examples, right? You can't defraud people, okay? You can't lie to them in a way that causes them damages, let's say. That's essentially what fraud is, in a way that they rely on. You can't defame people. You can't lie about their reputation, again, in a way that causes them damage to their reputation. You can't incite violence against others, right? You can't threaten people. So where does it say in that amendment that you're not allowed to do any of those things? And just take it from me, it doesn't actually say that in the rest of the Constitution either. Okay? So my point is this: to make these words have effect, to give them the effect that the founders understood them to mean and intended, at least when you think about the founders' philosophy, we need a theory, right? If you've ever heard the expression, it takes a theory to beat a theory, okay? We need a theory of the First Amendment if we're going to overturn what is becoming the theory that I've outlined by showing you the ideas that I did before. And to put it the other way, if somebody else has a theory that is going unchallenged, it's going to inform how people in the courts read these words, right? So if, for instance, philosophers like those that I pointed to before, if they are able to convince the courts that speech is a threat to your welfare, right? that it actually threatens you, that it puts you in an unsafe circumstance, or that some groups are using speech to literally oppress others, what do you think the courts are going to do? Right? If you take those ideas seriously, they have no choice. Of course they're going to find against freedom of speech, at least in our conception of it. All right, so let me give you two quick examples of how this has played out in the courts. They're just two examples, and I want to stress the sky is not falling, right? I mean, protections for free speech remain robust, but what I'm talking about is where are we heading, right? What does the future look like? So the first one, this is a case called Austin versus Michigan Chamber of Commerce. Now let me read the quote and then I'll tell you a few things about this case. So resources amassed in the economic marketplace should not be permitted to give some people an unfair advantage in the political marketplace. What they're talking about here is political speech. So the fact that people have a lot of money and can spend it on political speech shouldn't give people an advantage over others when it comes to discussing candidates or even one could say ideas. Now, this is a case that justified limits on people spending money on political speech. Now, the thing about it is it's been overturned since Citizens United came down. Citizens United overturned this case. So why would I be citing a case that's overturned? One reason is 78% of Americans want Citizens United overturned. It's probably one of the most hated decisions in the nation's history. And part of the reason for that is the ideas that I discussed before. Now, there's much more to it. But egalitarianism, I could put the point like this. Campaign finance law and restrictions on political speech can be boiled down to the principle of egalitarianism. It's wrong for some people to have more influence than others. And many, many people accept this idea. It's what gave rise to this case. And in my view, if Citizens United is ultimately overturned, we're going to see that principle applied far more thoroughly and broadly than it ever has been before. I mean, all you have to do is listen to Bernie Sanders for 15 seconds, and he says this like 26 different times. All right, now the next case I'm going to give you an example of requires just a tiny bit of setup. It's a case that came out last October. It's a lower appellate court case, and so that's one step down from the Supreme Court. And it involved a group called Bible Believers in Michigan. Going into so every year in this county, I think it's Wayne County, Michigan, there's an Arab festival put on, and it's done in a public place. So if you've ever been to a city that has these kinds of festivals and all kinds of various types of street fairs and the like, you essentially get a gathering of people who are getting together to celebrate whatever it is that they're celebrating. But it's in a public place, and as being in a public place, it's entitled. It's as a public space, people are entitled to both speak there in favor of whatever it is they're celebrating, or really for any purpose they want, so long as they don't violate other people's rights, so long as they're not harassing people or inciting violence or the like. And that was the situation. And a group called the Bible Believers went to this Arab festival, and they basically are there to try to convert people to Christianity. I'm an atheist, so I don't really see a whole lot of, I think they're all crazy. But so I'll just describe them crudely and bluntly as crazy religious people, right? Who are going to proselytize to all of the Arabs to change their views. But they were doing so peacefully, annoyingly perhaps, but certainly peacefully. Because they were saying things like, Muslims go to hell, and I think they had T-shirts to that effect. A lot of the people at the fair got angry with them. And the police thought that this was going to lead to violence, basically. So what the police did was they, instead of protecting the guys who were speaking out, they removed them from the protest. They basically said, "You, the Bible Believers, are instigating a dangerous situation. We're going to take you out rather than protect you." Now, to put that point in context, imagine if you wanted to give well, heck, we don't have to imagine, right? Think of the Garland cartoon contest, right? And imagine if instead of the police protecting those who wanted to speak out, they said, I'm sorry, you're not allowed to hold this contest because violence might erupt. Okay, that gives you a sense of when you think about this in principle, the magnitude of what's going on here. It's what's known as a heckler's veto, right? And in America, that's a really taboo thing under First Amendment law, right? The cops are supposed to protect those who are peacefully exercising their rights, right? So imagine, I mean, it actually has happened. Our government didn't protect Salman Rushdie. It didn't protect others who have spoken out. Certainly, other Western governments in Europe have not protected those who are speaking out. So that's the principle at issue here. What I want to do, the case ultimately came out the right way. So it may not be the greatest example, but I think it tells us where we're heading. So here's the ultimate point. This is from the dissent in the case. Now, everything I've told you is old hat. I mean, the principles of law that were at issue in this case are decades old. It should have been the easiest case in the world. And in fact, the majority came out the right way. But notice, this is the dissent. Notice what the dissent is saying here. Let me read it to you. It's unfortunately ironic for the Bible believers to succeed in their tactics in this case. In the greater Detroit community, it is the minority's cultural expression that loses from today's decision, right? They're talking about the Arab Americans who held the festival. The disruptors, that's the people who spoke out and were trying to proselytize, came from a different part of a larger community to disrupt the First Amendment activity of Arab Americans, a sometimes feared, misunderstood, or despised minority within that larger community. Now, the point here is not so much rooted in Arabs versus Christians. It's the idea that any court would take seriously the principle that free speech protections depend on whether you're part of the majority or part of the minority. All right? Remember the Gary Trudeau quote from before, right? Charlie Hebdo was punching downward at a disenfranchised minority, right? And therefore should be criticized, and if we really play that out, and they should just shut the hell up and stop agitating, right? This is the same principle that a federal judge on a court of appeals, that's one step below the Supreme Court, is trying to write into our laws, okay? So if there's, I can't think of a better example of how ideas really impact the interpretations that judges give to otherwise pretty clear language. The First Amendment is among the clearest things in the Constitution. And yet here we have a federal judge saying, you know what? I really think we should decide this based on who I think is in the majority and who's in the minority, which is crazy. I mean, this is collectivism, egalitarianism. It's all of the ideas that I talked about that will undermine free speech if this becomes law. So it's cause for, in my view, great concern. Whoops. Oh, right. Sorry. That's part of the reason that it's cause for great concern, is that growing numbers of Americans actually support laws but banning offensive speech. All right, how did we get here? So a few words about what happened in American legal history to get us to this point, and then I'll just touch on how to defeat these ideas, and then I'll open it up for questions. This is a quote by a guy named Zachariah Chafee, who was very instrumental in developing thinking about free speech in the early days of the 20th century. He was a Harvard law professor, and I chose this quote because it really, I think, encapsulates a sort of what I would call a crack in the foundation of free speech law. As I said, the courts have issued many really good decisions, but it's this idea, I think, more than anything else, that has opened up free speech law to the influx of a lot of really bad ideas. So this is what I wanted to point to. So the argument here is, or the idea is, the principle on which speech is classified as lawful or unlawful. So the line between lawful and unlawful speech, or another way to put it is, whether or not speech should be protected under the First Amendment, depends or requires the balancing against each other of two important social interests. The first, public safety, and the second, the search for truth. So let me ask you, what's missing from this statement if we take rights seriously? This is balancing one social interest against another. Okay, the individual is what's missing here. Okay, I mean, ask yourself, how is a court supposed to decide how to balance the public's interest in safety with the public's search for truth? I mean, what does it even mean to say the public's search for truth? Truth is an individual thing. I mean, certainly we cooperate with others, we debate with others to find the truth, but ultimately truth and knowledge come from individuals' assessment of the world. It's not some, weird kind of vague public process. And yet this is the view that is stayed with the courts throughout the entire 20th century. It's the idea that the purpose of the First Amendment, or the purpose of free speech, is to kind of protect a social function. And ultimately, when judges make these decisions, they have to balance one social function against another social function, which leaves open, I think, it's not just leaves open, but it really is inherently a collectivist approach that misunderstands the whole purpose of free speech and certainly jettisons the idea of individualism and individual rights. There's nothing here about rights. In fact, Chafee, like many other thinkers of his time and today, thought rights was, as Jeremy Bentham once put it, nonsense on stilts. And you cannot protect freedom of speech if you don't have the concept of rights. So let me then turn to what do we need to defend free speech. And the way I would put it is we need to rediscover the Enlightenment ideas of reason over mysticism, egoism over altruism, individualism over collectivism, and limited government. Now, I'm going to rely from here on out on two quotes by Thomas Jefferson that really round these points out. Jefferson was a really smart guy, so it's good to quote a guy like him. This institution, he's talking about the University of Virginia, but it's the ultimate point here is what he's conveying about the human mind. This institution will be based on the illimitable freedom of the human mind. For here we are not afraid to follow truth wherever it may lead, nor to tolerate any error so long as reason is left free to combat it. Right? So this is the idea of the supremacy of reason and that we follow reason to where it leads. Now this leads to another point that Jefferson made, which is the proper role of government in protecting free speech. And as he puts it, the legitimate powers of government extend to such acts only as are injurious to others. It does me no injury for my neighbor to say there are 20 gods or no God. It neither picks my pocket nor breaks my leg. Reason and free inquiry are the only effectual agents against error. So the ideas that Jefferson is getting to here are reason over force and a government that polices that line. That is the key. I would say these are the irreducible conditions of having a right to free speech in any society, is that we respect reason ultimately, and obviously that reason has to prevail over force, and we need a government that properly polices that line, okay? Which is another way of putting it, putting Ayn Rand's point that the proper purpose of government is to ban the initiation of force. Or you can put it in the terms that that I quoted her earlier on. You either believe in reason and persuasion on the one hand, or mysticism and force on the other. Those who believe in irrational ideas will always resort to force. So let me end there, and I'll have a few words to say after the question period about some of the things that we are doing here at ARI, but I think this is a good time to break, say thank you, and ask if there are any questions.
Sure. Public safety and truth. I mean, if I have a bridge, I want to calculate the stresses right. Like, I'm not sure that I see exactly what the conflict is.
It's not a conflict between public safety and truth. So I guess 2 points. One is those things are not in conflict. Let me back up and say all of the confusion that the Supreme Court and I think the courts have had, not just about this issue, about freedom of speech, but about all rights, is due to the lack of a coherent theory of rights, right? So certainly throughout the 20th century, and I think even before that, even back to the founders' time, there was this view that rights are in conflict and it's up to courts to kind of balance and just sort of draw an arbitrary line somewhere based on, and they needed some way, some standard for deciding that. And the standard, at least in the 20th century, has always been the interests of society. And so the first point is, if the interests of society is the standard, it's number one, it's not a standard at all. There's no such thing as society or the public, right? So it is, it's an inherently collectivist approach. And what that means is this. So Ayn Rand put it as, if you don't mean by the public good literally 100% of people in the public, then what you're necessarily talking about is sacrificing some people's rights to other people's rights. So if we have a standard that holds that the ultimate way to judge whether or not you're allowed to speak is the public good, which I think is embedded in that, we're necessarily already thinking in terms of sometimes we'll have to silence some people to make room for others. So, I mean, think about it in the context of, let's say, the Garland attacks, or Charlie Hebdo, or another incident which was the Reverend, I think his name is Terry Jones, is it? He's the guy in Florida who wanted to burn the Quran, okay? So when that happened, when he threatened to burn the Quran, Justice Breyer actually was interviewed. And he said, look, if violence breaks out anywhere on earth because this guy is threatening to burn the Quran, it's on him and we can shut him up, okay? Now, I think that's a crazy view. Why? Because I mean, you have a right to say or think or do anything you want so long as it doesn't violate the rights of others. But the standard can't just be, we're going to try to weigh the relative costs and benefits of you speaking out. You're just a lone individual who wants to do something crazy. The public's interest is in safety, and you lose because you're outnumbered by all of these people who will be harmed. Now, there's a way to judge how to draw the line between incitement, let's say, and free speech, but that's certainly not it. And I think a lot of the people who criticized Pam Geller and the other people who put on the Muslim cartoon or the Muhammad cartoon contest were employing the same kind of standard. This is a threat to society in general. And why do your rights? So remember what Donald Trump said. Why don't you just draw something else, right? I mean, what the hell are you doing? This is stupid. This puts people in danger. Just, stop speaking and go along, go with the flow. So that's part of the issue. The other part, well, I don't think I had another part. Oh, no, I'm sorry. The other part is it misses entirely what the purpose ultimately of free speech and then the underlying value of free thought. It's reason, okay? And we have to understand that reason and then thinking and free speech have ultimately a moral purpose, a purpose that relates to our lives. And I would put it as gaining knowledge, understanding the world. As Ayn Rand put it, we can't survive if we don't think, okay? That's the real essential moral purpose of thinking and then communicating with others, is achieving values in our life, right? But Chafee and many other modern thinkers think about it as, I'll put it like this: truth and knowledge come from everyone in general, but no one in particular. It's a sort of aggregate collective process. They really believe that. And there are philosophers who think, the pragmatists certainly thought that. The progressives thought that. And it's embedded in I think, moral views and views of achievement and value even up to today. So it's kind of like saying, you didn't build that. It's the same basic idea. You're not responsible for what you created. Society created it. And if you're not responsible for what you created, we can just take from it what we will. So if you apply that to the free speech context, it's, knowledge doesn't come from individuals. What difference do individuals make? Knowledge comes from society, right? Or to put it as Oliver Wendell Holmes put it, and he definitely believed in this kind of collectivist viewpoint, and he was very much a subjectivist or a mystic when it came to the idea of knowledge and truth. He put it as the best test of truth is its ability to get accepted in the marketplace of ideas. Now, there's some truth to that. There's some, it's not completely wrong to say that having a process of debate and discussion is necessary often for individuals to arrive at truth. But that doesn't mean that truth is something or knowledge is something that collectives create. If the collective creates it, the collective has the right to dispose of it. So that's the essential point. Anyway, I'm going to stop there, but yeah, so I'll leave it at that because it'll get too detailed if I keep going.
My question is one of the things that you just talked about very briefly in your first answer, and it's the line, what is an incitement to violence? Maybe you have some ideas in addition to what is commonly taught in law schools. Maybe if you can talk about the difference between the two.
I mean, the standard in law, in constitutional law today for incitement, and everybody knows what incitement is, presumably. It's essentially calling on others or inciting violence, right? So something you say causes other people in some way to be violent and stirs up violence. And of course the problem is, as I illustrated with the example of the heckler's veto, people get mad at all kinds of things that people say. So if the standard is enough people are pissed off at you, then free speech is gone, right? So that can't be the standard. So the classic standard was given by the Supreme Court in a case called Brandenburg versus Ohio. And it essentially amounts to statements that in a given context create a threat of imminent danger or violence. I would say that's basically right, but it leaves a lot out. So the way I think about it is this. In order to be guilty of incitement, you effectively have to be intentionally trying to cause or to commit a crime. So an easier way to think of incitement, or an easier way to think of really, I think, all criminal violations is the person intentionally engaging in conduct that would violate somebody else's rights if he were actually successful at doing it, right? This is why a threat is against the law. A threat is you are essentially acting like a criminal towards somebody else. You're just not actually acting on the ultimate threat. But you're causing them, if they're a reasonable person, to behave in a way that essentially treats you like they would have to treat you if you were a criminal. So think of it like this then. If I'm a bank teller and I give a bunch of thieves the combination to the safe, okay? I don't actually open the safe. I don't go in there in the middle of the night. I'm not the one who perpetrates the crime. I'm just as guilty as they are. Why? Because I participated in the crime. And as long as I intentionally did it, I didn't do it by mistake, I'm just as much a criminal as they are, right? That's the idea of conspiracy. Or you could think of it as aiding and abetting, right? With aiding and abetting a criminal, we don't just prosecute the criminals themselves, we prosecute people who help the criminals as long as they're intentionally doing it. They're effectively acting as criminals. If they know what they're doing and they're helping a criminal achieve his criminal ends, then they are participating in the crime and we have to convict them if we want to protect ourselves and have a just system of laws, just as we would convict the criminals themselves, right? Because we know that cooperation is often a useful way to get things done. That's just as true with criminals as it is with law-abiding citizens. So the way I think of incitement is you as the inciter are essentially trying to participate in a criminal scheme with a bunch of people that in a circumstance your words can be taken and would reasonably be taken from, by a reasonable person to be calling for violence in a given circumstance in which violence is likely, right? So if I say right now, let's all attack a Mitt, right? Probably that's not going to happen. Everybody would be like, I can see why you might want to say that, but it's probably not going to happen, right? But if we're in a circumstance like the Missouri, you remember the Missouri riots after the shooting of the young black kid by the white cop. In a circumstance like this, where tensions are high, and we know that riots have been happening and are possibly imminent, and somebody stands up in the parking lot of the 7-Eleven and says, that guy participated in killing this kid, let's go destroy his store. And he intends that to be the result, or one would infer from his comments that that's a natural and foreseeable result. He's guilty of incitement because of that context. Or let's say you travel to, the parts of Paris that are, seriously, there's a large Islamist population within parts of Paris, right? And for some strange reason, Pam Geller goes with you, right? And in the middle of a big crowd of angry Islamists, you say, there's Pam Geller, right? She's the one who sponsored that contest. In a circumstance like that, it's entirely foreseeable that everyone's going to attack her. And as long as you can be shown not to have somehow made a mistake, you can be guilty of causing the harm to her. That's the way I think about it. I mean, I think, does that clarify it?
Right, but then would you not have a right, for instance, just to go into the middle of that area and draw the cartoon?
Yes. Yeah, I think you would, and it would be up to the police to protect you. So the question, though, comes down to this. Are you engaging in conduct that is intentionally or recklessly designed to violate somebody's rights? That's what I think it really boils down to. Now, I mean, you can spin out hypotheticals for a long time, and ultimately what law professors typically say is if you change the facts, then the outcome will be different. But yeah, you have the right to engage in peaceable conduct that is not designed or foreseeably will violate people's rights, and the police should protect you in that. The difference between somebody who is committing a crime and somebody who is not committing a crime typically turns on, are they intentionally or recklessly doing something that obviously will naturally lead to the violation of another person's rights, force being used against them. But I mean, there are a lot of cases in which I would have to confess I'm not sure. So something like that, walking into the middle of the worst, neighborhood in Paris, and I don't know, creating a big statue of Muhammad, or and burning him in effigy, and then that leads to a riot. Is that incitement? And my answer to that is I'm not quite sure. But I can tell you what the principles are. The principles ultimately are you intentionally taking steps that will or reasonably or foreseeably lead to violence against particular people?
Whose right is violated?
Well, if the in that circumstance, it would be all the store owners and everybody whose property was damaged. But if there's no damage, then I don't think there's any crime. But I mean, it's a hard question. But I think the principles, if you think about it as either like you're analogous to a criminal, you're somebody who is trying to put in motion a series of events that would lead to the commission of a crime. That's what incitement is, I think, in its essence. You're trying to violate a person's rights indirectly.
And so whether the hearer is rational or irrational doesn't necessarily matter?
Well, I think it does matter, but it depends on the circumstances. But I'm not 100% sure of that one on my own. So, for instance, I could say on the one hand, the guy who burned the pile of Korans in Florida is definitely not guilty of anything, no matter what, no matter what you might say people would do abroad, because there are so many intervening steps. There are so many choices that other people who are capable of making choices and being rational can take to prevent that. So the intervening actions of a perfectly rational party who can make their own choices matters. But I do think there are circumstances, or at least I'm not sure, possibly there are circumstances in which it's like throwing a match on a pile of dynamite and then claiming, gee, I'm not responsible for what happened.
You
Hi.
mentioned the not so hypothetical, somebody saying at his rally that if you beat up that protester, I'll pay all your legal fees for you. That might be going over the line.
Yeah.
But thank you for the fascinating presentation. You covered a lot in an hour. I think there's a really severe attack on free speech coming from the Marxist school of social justice.
Oh, yeah.
Warriors and cultural appropriation accusing everything of being cultural appropriation and all speech of being
Yep.
a violation of social justice one way or the other. But I wanted to challenge the concept of the free speech and free rights of man going hand in hand. And putting aside commercial speech, which has expanded under the Berger and Rehnquist courts, because in the 19th century, because there wasn't nearly so much government regulation, commercial speech wasn't an issue.
Mhm.
But on both incitement, which you mentioned, and libel, I would say the First Amendment is much better off than it was in the 19th century.
Oh yeah, no question about it.
And how do you account for that? I mean, we were, certainly in terms of rights of property, much better off in the 19th century, but in terms of incitement and protection of, on both incitement and libel issues, if Trump isn't elected, we're much better off. Yeah,
I think that's a great question. So I've thought about this for a long time and tried to, so my answer is it's primarily kind of historical and ideological. So, but let me put your question slightly differently, because I actually think you can ask the question in a way that's even harder to answer, or it's sort of more favorable to your position. 20th century free speech law, it's pretty much when free speech law begins, in the early 20th century. Before that, it's not very good, right? So you have the entire, the founding period up through the 19th century when free speech law wasn't all that good. Now, understand there weren't that many opportunities for government to violate people's rights to free speech until the 20th century. So you have two things going on when you get to the 20th century. One is the growth of government, right, and more opportunities to violate the right to free speech, and therefore more reason for courts to actually pay attention to it. So on the so there's a reason to actually build a body of law at that time. But at the exact same time, you also have the rise of progressivism, okay? But I think what happened is this. So progressivism is ultimately against free speech. It's pro-collectivist, pro-statist, anti-reason, I think, at its foundation, which, as I've argued, is against free speech. So how do you explain the fact that our laws developed? So I would say this. You have two things going on. One is kind of a holdover from a 19th century view, and there's still respect for individual rights to some extent at this time period, in the beginning of the 20th century. But you also have a recognition. Now, I'll say this tentatively. You have a recognition among the people who are the ones who are, kind of arguing for a counter Enlightenment and counter-American tradition, which is the progressives. You have a recognition among these people that, you know what, we can't succeed if we don't have some protections for free speech. And I do think that they were mindful of the fact, because if you look at the old progressives, sort of 19th century, they didn't care a whit about free speech. And there's a lot that you can find where they comment on free speech as, this is a sort of tiresome, individuals shouldn't be able to speak. They're countering what the majority wants. They're countering democracy. They're countering the will of the people, so to speak. And they didn't care about it at all. And if you just took that, you would have expected progressive justices and thinkers not to support free speech. My hypothesis is they understood at some point, or a significant number of people did, that the only way we are going to be able to succeed in promoting our views, which, it was socialism, anarchism, communism. A lot of the early free speech cases involve all three of those types of people. And the court, which is sort of an old guard 19th century court, initially saying these ideas are, they're going to corrupt our morals and they're going to destroy our country, so we can't protect them. And you have the progressives recognizing if we don't have protections for free speech, we can't succeed in our reformist efforts. And that's why you got initially a pretty good free speech law. But as I argued, and I think maybe I had to make the point a little clearer, but ultimately it got off on a kind of mixed foot. It was, yes, protections for free speech, but because it promotes some social goal. And I think that's what's ultimately undermining. You can see that in the area of campaign finance law. You can see it in any other areas that are bad on free speech. But we do have still in this country a tradition of, to some extent, limited government and at least a tradition of free speech. So let me make a point that I don't think I made this earlier, but one of the reasons that Jefferson advocated a Bill of Rights is not because he really thought the courts would enforce the Bill of Rights and preserve freedom. It was because the Bill of Rights will remind the people of their rights. And I think this, so the one thing that I would say about the First Amendment, not the one thing, I mean, it's the jurisprudence on this is quite good. But what I would say, or we may look back and say that the greatest, what the First Amendment ultimately achieved was creating a real tradition that got embedded in law, in 20th century law, which was real respect for free speech. Now, it wasn't perfect from a philosophical and moral standpoint, but you have a real tradition in this country that one ought to be able to say whatever one thinks. And I think that's a holdover from a 19th century or 18th century point of view. But I mean, your point is a good one, and I've wrestled with it for a long time, but that's what I think explains it.
You have Justice Douglas, who is an absolutist on free speech, and then the government can do whatever it wants on everything else.
Yes, that's right. I mean, there are other reasons too, but I don't want to get too much off on a tangent. I mean, what I've provided is a kind of a centralized view of the ideas that are threatening free speech and the ideas that have found their way into the courts. You have all kinds of justices that are all over the map, great on free speech in some ways, but you can see a real change. So Justice Jackson is one who was very good on free speech. So if you read cases from the 1950s, what you'll see it put is freedom of thought or freedom of conscience, not just freedom of speech. They understood that it was about free thought. You don't see that in decisions anymore. It's about free speech, and they don't talk about it in terms of rights anymore. That's changed even over the last 60 to 70 years. And there are very, very few decisions out there until Citizens United came along. And it's very difficult to find cases that even talk about the individual's right to think for himself or speak for himself. It's almost always couched in terms of society's rights or social goals. And I think that's gotten worse over time. But that's a really good question.
The last question addressed the concept of cultural appropriation. I want to ask about that. Your thought of this whole concept of the court of public opinion. Last year we had stories like the Donald Sterling incident and the dentist in Minnesota killing the lion and losing all of his business. And I remember seeing this Tumblr account one time called Racist Getting Fired, where people would post screenshots from social media of people saying horrible things, and then they'd get them fired. And my question is, what's your thought about that in pertaining to free speech? Do people really need the government to crack down on people to enforce cultural appropriation, and also, if people aren't speaking up for the people losing their jobs from racists getting fired, are they going to really stand up when Loretta Lynch starts prosecuting people for denying climate change or things like that?
So, I mean, the core of your question, I think, is like, maybe I would restate it as, is this sort of thing that you've talked about a free speech issue when people gang up on social media on people, they end up getting fired or vilified, right? Publicly vilified. And the short answer is no, I don't think it is. You can call it a horrible thing that people shouldn't engage in, but I don't think it's a free speech issue. I mean, it's people stating their views and then other people acting on those views. People have every right to fire whomever they want. They can be irrational or rational in that, but I don't think it presents a free speech issue. Now, a lot of these kinds of fights, though, I think betray attitudes about free speech. So to get back to Mark, one of the points that you made about social justice warriors, and I agree wholeheartedly that a lot of the ideas that are against free speech are coming from that segment of the left. I've referred to them as postmodernist, or I think you can lump them all together as new leftists, because the thinking begins pretty much in the 60s. In my view. I mean, there's a lot of different strains of ideas here, but it's egalitarians, it's subjectivists, it's people who are generally speaking against individual rights and very much pro government, among many other things. in a lot of these controversies, you can see attitudes about the idea of free thought, respect for reason, respect for reasoned deliberation in coming to conclusions, just pushed right out the window in favor of a real kind of emotionalism, a culture or a kind of a culture of condemnation, of sensitivity. It's a real anti-reason, emotionalism over reason kind of culture. But I don't think that the points that you're raising really are free speech issues. They're issues of proper behavior, rational versus irrational behavior. But I don't think that they rise. There's no indication, at least in any of the examples that you gave me, that anybody is violating somebody else's rights or that the government is censoring somebody. So, sure.
One, you cited the Citizens United case, and there's a movement in California called California Clean Money, which seeks full disclosure. And the last time they got it in the legislature, guess who killed it? The unions.
Oh, of course, yeah.
They didn't want anybody to know.
Yeah.
So it's whose ox is getting gored?
Well, so the question is about Citizens United and the fact that unions are as much, the way I would put it is, unions were as much in favor of the Citizens United case as many other organizations like corporations that stood to gain from being able to speak out, and specifically to speak out about politics. There's definitely something to the idea of whose ox is getting gored. I don't really think that the unions are purists on free speech. I think that they know that they want to be able to influence the political system. But I have to say, I agree with them on this, at least in principle, that I'm against disclosure laws. I don't think the government has any right or authority to force you to disclose anything about yourself just because you want to speak out. That is tantamount to saying or deciding to edit what it is you're saying or what information you choose to disclose about yourself. If they can force you to disclose information about who funds you or who is a member of your club, why can't they say, and by the way, you forgot to add these extra arguments. You forgot to add the other side's arguments, so you're not being diverse enough. That's essentially government as editor of what people say, and that's not permitted in my view under any coherent view of free speech. Sorry. Actually, let me go to the guy behind the mic, and then I'll...
do you have any kind of feeling for what the definition of hate speech is? Is it just cognitive dissonance?
I don't think there is a definition of hate speech, but there is such a thing as harassment and threats. So I don't know exactly where the term hate speech comes from, but I'm pretty sure it gets its start sort of in the civil rights era, like 1960s, 1950s time frame, and before that. And it's very much connected to really horrifying, not just racist speech, but racist actions, which is to say threats, okay? So the quintessential example of hate speech, at least when I was in law school 20 years ago, was burning a cross, okay? But burning a cross is a threat. It depends on how you do it. If you burn a cross on your own lawn in a place where no one can see, I don't think that's true. But if you burn a cross in front of someone else's house, that is definitely a threat. There is a clear objective meaning. That's the Klan is on the way to lynch you and your family, right? That's a threat. But this idea of hate speech sort of developed around racist speech, and now it's been expanded effectively to include anything that offends somebody. And if you read the European laws that ban hate speech, they're crazy. If you say things that incite hatred or offense or about which people would take offense on the basis of race, sex, and the usual suspects, you've violated their rights and you violated the law. That's crazy. That's not. It may be impolite, but it's not a threat. So I don't think the term hate speech has any meaning. Ultimately, hate is in the eye of the beholder. It's a purely emotional reaction to something. People hate all kinds of different things. But that doesn't mean harassment and threats are protected speech. So if you threaten somebody, which has to be a specific threat of violence or in some sense using force against a person, to put it in essential terms, or you harass somebody. So you're calling them constantly on the phone and creating in them the fear that they're going to be attacked or something like that. That's a violation of their rights. But that's not what, it's important to recognize, that is definitely not what hate speech laws are all about. They are not about threats. They're about clamping down on speech that some people find offensive, on the argument that offensive speech marginalizes people and essentially oppresses, as Gary Trudeau put it, disenfranchised minorities, which is a crazy idea and definitely anti-free speech.
Suppose the government arrests you for telling a lie, like not about opinion, not a matter of opinion, but you say 2 + 2 = 5, and they prove in court you knowingly told a lie. What would be wrong with that? Because, as you said, the purpose of free speech is to be rational. Is that?
So yeah, the purpose of free speech is not to be rational as such. The purpose of free speech, or the genesis of free speech, is the fact that reason can't function under compulsion, and that you cannot force people to believe either good ideas or bad ideas. You can't force them to believe anything. Reason to function and to be what it is, and to be the sort of foundation of not just our rights but our lives and our ability to conduct ourselves in the world, has to function freely. You have to initiate it yourself. You've got to focus yourself on what it is that you're thinking about, and you've got to engage your rational faculty to come to conclusions and guide your own life. That's the genesis of the right to, call it the right to freedom of thought, and then the right to free speech is a corollary of that, which is communicating with others. But it doesn't mean that those who engage in irrational thinking or irrational speech, that you can outlaw that. The only way to for anybody to arrive at the truth and knowledge and to pursue values is to be free to do so. So in effect, think about it like this, to make it concrete. It would be tantamount to people coming up to you and saying, if you don't come to the right conclusion, I'm going to blow your brain out of your head. Which is weird, right? I mean, like, what's the point of this exactly? You're essentially setting the person's own mind and their own rational faculty at odds with their life, right? They can't possibly function in that way. It's definitely wrong for the government to outlaw lying. It is appropriate, in my view, to outlaw certain types of lying that amount to either fraud or libel, that, in other words, cause damages to people. But it's the damage, it's the physical damage that is the key.
I mean, suppose you're a math teacher. You clearly know 2 + 2 is 4. So you're saying it's 5. So you're thinking free. You know the truth, but you're telling a lie. If the purpose of rights is to be rational,
well,
do what is right, then how does it violate?
So let me elaborate on the point. The ultimate purpose of rights is to ban the initiation of force from human affairs, because it's only in a circumstance in which people are free to think and act that they can act and be human beings. They can live human lives, right? So, I mean, the philosophical derivation of that is much more complicated, but the basic principle is banning the initiation of force. So people are free to think and say whatever they want to, so long as they don't use force against other people. It's force that prevents us from living as human beings. Now, the reason for that is that you can't function rationally under the threat of force. But it doesn't mean that if you decide to function irrationally, that gives the government the right to force you. I mean, one way to think about it is behaving and thinking irrationally harms no one but yourself. There's absolutely no grounds, either morally or politically, to prevent that, prevent people from lying or thinking in ways that are irrational. As long as people are free to make their own decisions, or as I've put it before, free to walk away, they can continue to function as individuals. They can separate themselves from the irrational person and prevent that person from harming them. It's only when a person uses force that they can actually threaten other people's lives and prevent them from living lives and their life and pursuing their values.
One of the stories that's in the news today is the story of Apple versus the FBI court case.
in the case was that forcing them to create a backdoor to the iPhone was tantamount to violating their free speech or their First Amendment right. Can you elaborate on what the lawyers were basically trying to argue on behalf of?
Well, I mean, the argument would, let me back up and say a few preliminary things. First, I'm not an expert on this issue, and I've followed it in general by reading, in the newspaper what's going on. I don't really understand the technology issues, and that's a big deal. You do have to understand this, I think, to thoroughly understand the issue, and I won't say that I do. But I can tell you what I think the argument was they're making. It's this: creating computer code and writing programs is, one could argue, an exercise of freedom of speech, right? I'm putting information down on a page, and just as the government can't restrict you from speaking, so it can't compel you to speak. So I guess what the engineers would be saying is, this amounts to compelled speech. You're making me, it's like saying, I'm going to force you to write a book that you disagree with. That really is an egregious violation of your rights, in my view. So you could argue that as a free speech violation. I think much more fundamentally, it's a violation of one's property rights, one's right to contract, one's just general right to be an autonomous being who makes his own decisions. There are all kinds of ways you can argue that, but because constitutionally the only thing left now is making a free speech argument, that would be the one they would naturally gravitate toward. But I think if things had turned out better, right, we didn't have the New Deal revolution in constitutional thought that expanded government's power and effectively cut off constitutional protections for property rights and the right to contract. One would just make a contract right or a basic property right. This is mine, and you're not allowed to force me to change this one bit. Now, the further question then becomes, does the government's role in preventing crime, or I shouldn't put it as preventing crime, but prosecuting criminals, give the government the right to effectively issue or obtain a warrant from a court that forces Apple to change its iPhones? My answer to that is absolutely no, but I would say, well, I shouldn't say absolutely, tentatively no, pretty sure no. And on one, I'll speak to just one thing because, again, I'm pretty convinced of one aspect of this and a little bit fuzzy on some of the others. What it amounts to is the government saying, and this doesn't really have anything to do with free speech per se, but it amounts to the government saying, even though you have no connection to this crime whatsoever, and you have no information in your possession that is at all relevant to this crime, which is true of Apple. It's not their phone, right? I mean, they own the software and the patent rights to it, but the phone was the criminal's phone, right? They had no connection to the crime whatsoever. If you hold evidence in your possession of a crime, the government can come and say, give us that evidence. That's perfectly valid, right? So if Apple had files in its possession that were, if the San Bernardino killers had worked for Apple, sure, the government could go and they could say, we're going to subpoena those records, you have to give them to us, and when we're done, we'll give them back. That's basically how it works. But this is a matter of conscripting a private citizen and saying essentially, we're going to force you to help us solve a crime. I don't think that that's at all consistent with the fundamental idea of what a warrant is or what the search and seizure power under the Fourth Amendment is in law or in logic. And think about the consequences of that for a minute. I mean, does this mean anytime somebody uses an iPhone to commit a crime, now we can enlist and conscript Apple to help us solve the crime? Or broaden it from there. Just take a really simple example. Somebody got murdered in this town, right? And we know there's evidence out there in the woods somewhere, but we only have 5 people on the police force. The whole town is now conscripted to go search the woods for the next 15 days until we find that evidence. Or there's all kinds of things that the police need better guns. We're going to force you, gun company, to build those better guns and give them to the police force at a cut rate. Or the government needs your property. Therefore, we're going to take it, and of course we'll pay you a market rate for it, but we're going to force you off it. That's what is so objectionable about eminent domain. The fact that it's connected to solving crime, I don't think changes anything. But I suppose I could be convinced otherwise. And it does turn to some extent, I think, on understanding precisely what it is that the government is asking Apple to do. But the fundamental, in my view, is it comes down to Apple has no connection to this whatsoever. It's like asking any private citizen we're going to make you help us solve crime. You want to hire them to do it? Go to town. If they freely decide to help you out, that's one thing, but I don't think you can force them to do it. Sure.
So the Apple thing, right? I have a computer science degree, and you know, encryption is built on hard math problems. Usually they want a math problem that's easy to go one way and hard to go back the other way, right? That's what encryption generally uses.
Mm-hmm.
So if you use a big enough, they call it number of bits, but it really has to do with, like, you know, it's how many digits, right? If you use a big enough number for the two numbers you use for the encryption, then it becomes computationally impossible to go back, essentially, right? It becomes, you need like 1 billion
Yeah,
years with the
right.
fastest computer in the world to decrypt it, right?
Got it.
So, you know, not more than, 20 years ago, right? The government used to say that if you used more than so many bits of encryption, you were not allowed to export any products that used, and the reason was because the government said, we can basically decrypt anything with this few number of bits.
Yeah.
And we want to make it so that we can get into anybody's device
Right.
if you export it, right? But they finally gave up on that. But now they're back on that, essentially that sort of idea of, you know,
Yeah.
Apple is trying to lock down all the possible ways that anybody could ever break into your cell
Yeah.
phone except
I-
you.
so-
And the only way they can really do that is to make it so even Apple can't get it if they had it in their hands.
So, and which way do you come down? You're
Well,
saying.
I'm with Apple, right?
Yeah, okay.
I want to be able
So
to have a phone that
let
nobody
me
can
say
get, right?
one more
Buy-
thing on this.
buy
And so
box, right?
the basic question, so I can reformulate your question in terms that I at least understand. And in much simpler terms, right? So the issue gets to this. What happens if private citizens can put certain evidence beyond the reach of government ever, right? What do we do, okay? And so I'll give you a really low-tech version of that, okay? The low-tech instrument of putting evidence beyond the government's reach is the fireplace, okay? You can burn stuff up in your fireplace, okay? Or just my door is locked, you know, under my floorboards. I mean, people can come up with all kinds of ways to put evidence beyond the government's reach. If you knowingly, well, no, but I mean, if you knowingly do that, knowing that this is evidence that's relevant to a criminal investigation, you've committed a crime. And we already have laws in the books that say that, okay? But if you just, I mean, the mere fact that technology, right, exists that can put evidence beyond the government's ability to find it is not only, I don't think it's relevant to the issue, but it's also a really old problem, right? It goes all the way back to the Stone Ages when fire was invented. I mean, I'm not kidding about that. I mean, it sounds silly. Okay, the shredder, right? I got one in my office and I feed stuff into it constantly. And you know, criminals use shredders all the time to dispose of evidence. So what are you going to do? Now you're going to go to the shredder companies and say, you have to stop building shredders because, you know, paper shredders put evidence beyond our reach. No, that's crazy. So, I mean, that's where I come down on this. As I said, I'm not, you know, everything I said very passionately is a little bit tentative in that I'm not totally sure that I've thought through all the details, but I don't think that the Apple issue is fundamentally different from anything that we've seen, you know, for the entire history of the Republic. Criminals have always been able to hide evidence, and it's always possible for government to conscript, you know, innocent people into solving crimes or to take their property or their freedom in other ways. It's not justified just because Apple has this so-called ability or supposed ability to do it. I mean, there's so many ways I could talk. I could carry on for a long time, and I don't want to take up too much time. This is one of the dangers of being a lawyer and standing in front of people. That everybody wants to ask you every question, and my problem is I'll answer all the questions. But I'll keep it at that. I mean, I'll continue to speak about this if people want to ask me more questions, but I want to move on.
I'm going to go a little off topic from free speech, so feel free to
Sure.
say so and just
Yeah.
ignore this. But would it be fair to assume you are not a fan of the All Writs Act?
I don't know much about the All Writs Act, so I couldn't. My sense of it is this: is that it's a sort of generalized. So ask yourself this: why is the government trying to use a law that was passed in 1792 in the interim between creating a constitution and passing all the laws necessary to give the government the authority to take actions? And my answer to that always is because they don't have the authority to do it in any laws that were passed like in the last 50 years. And that ought to create a kind of red flag over our heads, like this is weird. Why are they doing this? Why are they using this antiquated law when it's possible for governments there's all kinds of laws and criminal rules on the books that allow government to do what it needs to do to solve crimes. So that raises my suspicion, but I don't know a ton about the All Writs Act other than, it's old and that creates suspicion in my mind that the government is trying to accomplish something indirectly that they couldn't probably accomplish directly, but that's the most I can say.
They have a reasonableness standard built into it, so that's one of the things. I
Yeah.
mean, they can only ask a business for reasonable cooperation
Yeah.
or a reasonable assistance in connection.
I mean,
with
this strikes me as coming from a time when government could actually conscript like ships. We're gonna all of the private ships now are gonna be called into government service to go out and accomplish some purpose. It may have happened way back in the olden days and be a rich part of American history, but that doesn't make it okay in my view. Do you have a question?
Yeah. So to anticipate the question about how do we get better ideas out there, how receptive is in your view at least, how receptive is the legal profession to both better ideas and then the grounding of these better ideas, not just better arguments, but you gave examples of fish, and are they looking for answers to that or retorts to that, or are they dismissive of it?
I think it's mixed. But I'll give you, let me focus on the positive first. I mean, if you'd asked me this when I was in private practice, I would have given you lots of negatives, right? Because I was constantly suing the government and seeing bad judges doing all kinds of horrible things. But the reception, so let me dovetail this with what other things ARI is doing. And one of the things we're doing is speaking out more and more to law students. And part of the reason we're doing that is they're very receptive to, and I think eager for good ideas. And also self-selected for interest in ideas, intelligent, analytical. And our response so far has been really positive. And I've been really happy to see law students at top law schools I've spoken at really interested in our ideas. And I think part of the reason is that they're hungry for something other than just sort of dry, legal teachings that they often get that have no, and these are my words and not theirs, but no moral component, nothing to it that says this is the way the law should be. It all seems like just arbitrary rules. And this is what, the tradition of American law in the latter 20th century is legal positivism, which is legal rules just come from society and there's no rhyme or reason for it at all, right? And when law students see this, I think oftentimes I was, and many others they're starved for something more. And a moral argument can really resonate with them. And Yaron just spoke a couple of weeks ago, or maybe a month ago now, at a Federalist Society convention. Federalist Society is an organization of conservative legal thinkers and lawyers and law students in Virginia, and he got a great response on inequality, which is not, directly connected to legal issues. So it's been mixed. I would put it, in similar terms with what we see elsewhere, which is a lot of older lawyers who've been practicing for a long time are cynical and pragmatic, and they just think, what we have to say is utter nonsense. But I've gotten good responses. I gave this talk at a Federalist Society a chapter of lawyers in Austin, Texas a couple weeks ago, and I got a great response, and everybody was really, really interested. So, I'm hopeful that lawyers, generally speaking, I think they are generally speaking interested in ideas, but it's mixed. So we'll see. I'll keep working at it, and we can see what we can do. And ask me in a year, and I'll tell you if the reception has been better. But at least among law students, I'm very optimistic. And that's ultimately how you change the culture. You change what young people are doing. Others?
I have a question.
Sure.
Can you give me tactics or advice to a student on how to protect their First Amendment rights at a university that has the issue of safe zones?
So do I have any advice to a student who is at a university that has the problem of free speech zones or safe zones? Is that what you're talking about?
Yeah.
Let me give you advice that's a little broader than that. So a free speech zone is just a zone carved out at a university where you're allowed to speak. And usually it's like as big as this, so like one person can stand in it like that. And it's an obvious way for universities to kind of clamp down on speech on campus. Now, there are a number of issues involved in this, but one is, I mean, private universities can do that to the extent they want, and my advice is don't go to universities who have really repressive and horrible policies about speech and knowledge. So keep in mind the First Amendment typically doesn't apply to private institutions, but a university should embrace a kind of principle of free speech, which is, you know, the idea that we are going to debate and think about ideas, and we're going to hear what people have to say, criticize them. Now, there are some limits to that, but certainly I wouldn't allow, if I were the chancellor of a university, somebody who was, you know, in favor of Al-Qaeda to come speak on my campus. But, you know, absent those limits, even crazy ideas, if the students want to sponsor them, by all means, you know, come and have talks. So the advice I would give to students is have a coherent view of what free speech and free thought entails and why it is that they're values, right? It's about the pursuit of knowledge. This is, to get back to an earlier question, this isn't the only reason it's protected, but it is why free speech is a value is, you know, we want to pursue knowledge. And pursuing knowledge means being confronted with both good ideas and bad ideas and figuring out what the difference between the two is. Why? Because you have to think it out for yourself. So have a view of that, and then I would say the best thing you can do is confidently defend your rights to everybody you can. Speak out and be confident about it. Don't fall for the argument that you offended me, you're oppressing me, you're a racist or a sexist or whatever else is, unless you are, in which case don't do that. But I mean, most times it's not the case that people are engaging in racism or sexism or et cetera, especially on today's campuses. So don't be afraid and cowed by the people who hurl these accusations at you. It's hard, right? It means you're going to be a loner. It means you're probably not going to have, you know, a whole lot of people who support you and a lot of people who don't like you. But you know, I think the best thing you can do is confidently defend your ideas, and especially defend the morality of defending your ideas, right? I have a right to think and speak my mind, and the only way that we are going to solve our differences is by doing exactly that. So that's the advice I'd give you. And then if that doesn't work, just sue the bastards.
We give a plug to fire.org.
Oh yeah. Other questions? Oh sure, go ahead.
So I have a question about what you mentioned when you were talking about the court's interpretation of the First Amendment. You said that the courts are essentially rewriting the First Amendment, and that we need to get back to what the founders intended.
Kind of, but that's a good setup.
Well,
So
please do clarify.
Sure.
But I guess my question, if we are trying to get to the founders' intent, how do you, first of all, what is that intent? And then secondly, how do you respond to sort of this common criticism you often hear, which is that the founders were not an it, they were a they.
Yeah.
And they didn't necessarily have one unified intention.
So that's a great question. Let me put in a plug for Tara Smith's book on judicial review in an objective legal system, and she goes into this issue. If you don't know who Tara is, she's a PhD doctor of philosophy at University of Texas at Austin and an objectivist, and she's written quite a lot on this topic. It's a complicated and hard question. So the way I would put it, though, just to clarify, and if I said this, I apologize. My view isn't that what we're trying to do when we interpret the First Amendment is get to the founders' intent. What we're trying to do is understand the language that's in the Constitution. That's the first step. What does it mean? And to do that, you have to take the entire context in mind. You don't just separate out words and phrases and take them out of context of the rest. You have to understand the whole document. And from that, it's understand the purpose of this document, because that's relevant to what all of the various parts do, right? So the founders had a purpose. It's like constructing a machine. Okay, you don't understand how a carburetor in a car works, or fuel injectors, I guess, if you don't understand what the engine is supposed to do and what the whole car is supposed to do, right? And it's the same thing with constitutional interpretation. So the goal ultimately is to understand the meaning of the principles and the concepts in the document. and then understand what they objectively mean, which is to say, not what the founders necessarily would limit them to, but what the words objectively cover. I mean, it's a complicated topic, but let me try to make it a little more concrete. So, if it turns out that the founders believed that the only way anybody could exercise their right to free speech was pamphlets and standing on a soapbox in the public square, we wouldn't be limited to that. Why? Because the words free speech and Congress shall make no law abridging free speech or of the press, understanding them as concepts, cover much more than that, right? They're adaptable in one sense to modern times, in the sense that whatever rationally comes within the terms free speech, Congress shall make no law, et cetera, is logically covered by that language. That's how law has to work. Otherwise, law is rooted in a particular time period, and it would not make any sense to pass principles that are supposed to guide the behavior, not just of one person or 20 people or even one generation of people, but several generations of people, right? We know that progress happens, that people develop computers, all kinds of other things, and that logically are ways to exercise their rights to free speech. So the key issue is not what did the founders intend, or even what did all of the people who are alive at the time intend. It's what did they write down, what was duly passed as the law, and then what is the proper conceptual interpretation of that. Now I know that's a big subject. It's not something I can cover all of, in just one setting, but if I can, I'll say that it's not a matter of original intent or what passes today for original intent, which you alluded to, which is the meaning of the Constitution according to what everybody at the time thought. It's what do the concepts that are used in the law, what do they logically mean, what do they rationally cover, and that's ultimately what informs our interpretation of law. But as I said, it's a big topic. Tara's book is good on the topic, and there's a lot of other things that have been written on it. But it's like one of the number one things being debated in legal circles these days. So it's hard to cover it in a couple minutes in a question. But it's a good question. Anything else?
Yeah, just on this original intent. This is kind of a left field question, but it's a good way to wrap it up, I think, on the Constitution. It's been years since I read Atlas, but I recall at the end, Galt's been rescued, everybody's kind of calming down, and Judge Narragansett's got a copy of the Constitution in front of him, and he's lining out what he considers to be errors or poor judgment, whatever you want to call it. Promote the general welfare, I think was one, and what was the other ones, and if you can't...
No, the Commerce Clause was one, I think, but I mean, well, so that's what my suggestion, I don't know, it's hard to answer that. I guess what I would say is this. At this point in history, just tinkering with the words of the Constitution ain't going to do it. So, we would do really well by just taking the original Constitution seriously and enforcing that, right? Yeah. Now, that doesn't mean it can't be altered and changed in certain ways, but we're so far away from that, right? It's like we don't understand the basic philosophical convictions of these people. We don't understand, today's judges and legal thinkers. They don't understand the Enlightenment values that I talked about. They're bringing an entirely different perspective to a document that was written in an entirely different context. It's like the proverbial Martians coming down and trying to understand some thing on planet Earth that they have no context to understand. So the solution to that is not, okay, let's tinker with it a little, we'll change these words and that'll solve things. The solution is to teach people how to understand the document even in its original form, and then we can start from there. And I don't want to try to list everything I would change. I would change the Commerce Clause. I would actually change a lot of things, but it's based on 200 years of experience or hindsight. I think the founders did a pretty amazing job with the original Constitution, and the problem is not that they didn't write it well. The problem is that the people interpreting it in the late 19th century didn't want to comply with or take seriously what they'd done. All right? Thanks.